Thank you, Mr. Chairman. I almost feel like I want to finish that previous conversation before moving on to what I was going to say, because it seems to be a hot topic here. And I think what's being lost in the conversation is simply that the bill proposal that is before us sets up a test for whether or not a state law would be constitutional if this became an amendment to our Constitution. And maybe the good Senate chair has the opinion that the existing statutes regarding abortion in the state of Connecticut would be maintained by meeting that test. But that is just her opinion. And that should be the thing that people are measuring here when hearing that conversation. I promise to come back to that. I want to start at the beginning, though. For people watching, what we are debating is a proposal to change our state constitution to reflect a new provision, which would become Section 21 of Article 1st of our Connecticut State Constitution. And in what it would do, it would include some language, which I'm going to discuss in a moment. The bill title is a resolution proposing a state constitutional amendment concerning a right to privacy. And actually, at first glance, when I looked at this, I was like, I'm all for this. I have a reputation as being a more of a libertarian type of thinker. I am a small government person. I'm absolutely for protecting the rights of individuals. And I think the beginning of this proposal reads quite well. It effectively says that Article 1st of the Constitution is amended by adding Section 21, and it would say the right of individual privacy is essential to the well-being of a free society and shall not be infringed without the showing of a compelling state interest. And, there were some good arguments made here about, various things that might be thrown into question if you had something like that become part of our Constitution, because we have a lot of laws regarding privacy. Some of them were mentioned. I mean, the notion of medical privacy, the notion of due process rights under the Fourth Amendment, and search and seizure, whether or not someone owns a firearm, whether that's a compelling state interest or not. These are all very, very good questions. But for me, I would probably fall on the side of sure. I'm all for the freedom, and you can go ahead and try and challenge me any way you like. However, this amendment goes on a lot farther than simply guaranteeing a right to privacy. And I will tell you, Mr. Chairman, my number one objection to this thing is that I think it's just being done in a very dishonest and disingenuous way. First off, the amendment has very little to do with privacy, and that's quite clear when you start reading and you suddenly realize that this is about protecting gay marriage and abortion rights. And even worse than the bill title, which is merely trying to deceive the members of this committee, which certainly isn't going to happen because we're all going to read this relatively short bill. What's worse is that the question that would eventually end up on the ballot in front of the citizens of this state, giving them the direct opportunity to vote on whether or not there be a constitutional change, I find to be very, very dishonest. That question, before I even get into the language of the bill, this is the question that you would be asked on a ballot. Shall the Constitution of the state be amended to recognize a right to individual privacy? Sure. Including the rights of adult to intimacy and marriage with another adult, regardless of sex or race, and the right of all residents, and this is the key part, to reproductive freedom and to prohibit the state from infringing on such right without showing a compelling state interest. On the face of it, I would probably vote yes on that. The problem is, much like our constitutional amendment on early voting that we are still working on, the question that was on the ballot didn't give the meat of the question. It only asked if we wanted early voting. It didn't tell us whether that was going to be 2 days or 10 days or 14 days or 1,000 days, and that's still up in the air, although it looks like it's going to be 14 days. This is much the same. Simply using the term reproductive freedom in this question does not tell the reader what is being discussed. You have to go to the text of the bill to find out what reproductive freedom means, and that is identified on lines 12, 13, and 14, and it says reproductive freedom, including but not limited to the ability to make and effectuate decisions to prevent, continue or end one's own pregnancy. So it's abortion. It's not reproductive freedom. In fact, I don't know whoever coined that term because I find it tremendously ironic because abortion is the exact opposite of reproduction or reproductive freedom. I am a freedom person, and I would fight for the individual right of people to make their own decisions on anything. The question is abortion really
an event in town, and now I'm going to.
Pardon the minor interruption. We had some technical difficulty there, but the issue really is whether or not abortion is a question of privacy, and I don't think it is. I think that's kind of the problem with this bill is that it's couched in privacy when, in fact, the question is not about privacy at all. It was mentioned earlier that, questions that are presented to voters in constitutional referendum have to be clear. And that's true with all of our laws. There's actually a concept known as void for vagueness when we have bills that are before us that are confusing and hard for people to understand. I think the earlier discussion we had about the Voting Rights Act might fall into that category, actually. But I think that this question, because it does incorporate several different concepts, the notion of intimacy, the notion of marriage regardless of sex and race, and the lack of a definition to the term reproductive freedom all lend themselves to an argument saying that the question is not a valid question. So that's one thing that would have to be addressed for certain if this was ever going to go before the people of Connecticut. And I'm confident that if it ever went before the people of Connecticut in the entirety of the definition that is provided in the bill proposal, that it would never pass. And maybe that's why it's designed the way it is. I want to address these couple of issues directly. First off, as I said, abortion is different from reproductive freedom. And abortion is what is defined in lines 12 through 14. Decisions to prevent, continue, or end one's own pregnancy. That is abortion. That's not reproductive freedom. And it's not a privacy issue. The fact of the matter is that abortion, no matter how anyone feels about it, must recognize that it involves more than that one individual's right to keep that information private, because it affects other parties. A pregnancy probably involves another person. There's debate across the country about whether that's a viable reason to disclose certain information. But the fact of the matter is that at a certain point, many people in this country believe that the unborn child is another person. And as a result, you cannot make the argument for privacy any longer. This ends up being a question that is a much, much harder question. And I want to be sympathetic to people on the entire spectrum, because some people believe in absolute freedom to choose whether or not to have an abortion at any point during a pregnancy, from the very first moment of conception all the way up to the day of birth. And other people on the other opposite end of the spectrum say that they don't believe in abortion at any time whatsoever. I think the vast majority of people probably would agree that abortions that happen near the day of birth are potentially, certainly more controversial. And I think most people would say that that is something that they are not in favor of, whereas abortions that happen early on in a pregnancy are much more accepted by our society. I think that that's just a fact, and I'm trying to look at it from that perspective. I'll acknowledge for the sake of this committee that I'm very much pro-life personally, but I respect the notion that other people might not be. The fact of the matter, though, is that when you set up a constitutional amendment and it is going to incorporate language that would protect a decision to prevent, continue, or end one's own pregnancy, and require that that is protected by saying shall not be infringed without the showing of a compelling state interest, you're creating a pretty high standard for any policy to be enacted to prohibit any abortion whatsoever, including ones that are late in a pregnancy term. And just as simple as I can put it, that's my problem with this bill, is that it does something that I find frustrating, which is that it will take the decision out of the hands of the people in this room and the other legislators and lawmakers that were elected by the people of this state to make the policy, and instead put it into the court. I started this conversation by pointing out that the Senate chair made her comment that it was of her opinion that the existing laws would stand. But none of us know that. This decision will ultimately be made by a court if this became a constitutional amendment in the state, because that court would have to be the deciding entity to determine whether a compelling state interest was met to enact any restriction on abortion whatsoever. And that restriction could be anything. It could be parental notification for abortion. It could be record keeping. It could be privacy related. It could be whether or not abortion can actually occur, or what type of abortion can actually occur at any point in a pregnancy. Even a bill to create a state law saying that abortions within the last month of a pregnancy would not be allowed would be in peril, because it would be up to a court to determine whether or not there was a compelling state interest. Now, I would argue as a pro-life person that, yes, it's a compelling state interest to stop that abortion. I don't want to say any provocative language. I'm trying to be as even-handed here as possible, but for me, that's a life. And ending someone's life is something I find completely and utterly unacceptable. And the abortion argument is tough. I think we would all agree that it is barbaric to murder a child on the day of birth. But if you subtract a day from that, what's the difference? Whether or not the child was born or about to be born. And sadly, I think that this constitutional amendment would protect an abortion that occurs the day preceding a birth. I'll just say a word about the marriage equality section of this while we're talking about it. The fact of the matter is that this proposal, I think, is already the law of the land in Connecticut. But I'm going to use this opportunity to put myself on the record, because I've had a very frustrating time in the legislature on this subject, because I've been mischaracterized repeatedly in the press on it. And that stems from my vote against a justice for a judicial appointment, and that was Justice Luby Harper, because he was the deciding vote in the appellate case that determined that gay rights or gay marriage was lawful. I did not oppose his nomination and appointment because of his opinion on the subject, but simply that he had one, because I don't believe it was the right of the court to make that determination and take it out of the hands of the legislature. The legislature should have been the ones to determine whether or not that policy was viable or not. And as far as the policy of gay marriage, my opinion simply is that if I had my druthers, the government would not be in the business of marriage at all. They would just completely stay out of it, and that would be a private thing that people do or do not do based on their own preference. But if we're going to have gay marriage, then I think that the fact of the matter is people ought to be able to do whatever they want to do, but they should never be in a position to compel others to do things that they don't. It's just that simple. That's the way our laws are supposed to work in America. People should have freedom up until the point it rubs up against someone else's freedom. And in that respect, I think that you should be able to have gay marriage if you choose, but you shouldn't be able to compel a church or other institution to marry you if they don't want to, much less bake a cake or something like that. That is the choice of individuals to respect their own freedom, and we should live in a society where we acknowledge the rights of others to have theirs. So this conversation goes back to the point, which is that this constitutional amendment will deprive the people of the state of Connecticut from having a representative discussion and debate about what policies should be enacted with regards to gay marriage or abortion. And that, I think, is a mistake. In one sense, we would be creating a question to guarantee all abortions without giving those individual voters voting on the question much choice about what that actually means. There's a lot more I could say about this issue. I'll just say that I'm going to vote no today, despite the fact that I'm certainly fall on the side of wanting to protect a right to privacy as much as possible, but that this language does not have anything to do with privacy. It has to do with abortion quite specifically. And there is grave danger, in my opinion, of this becoming a constitutional amendment, superseding and overriding the existing state laws that we have in Connecticut, and ultimately protecting late-term abortions and further prohibiting things that I think would be very valuable policy in the state of Connecticut. Parental notification of abortion, for one, and parental notification has its value in catching bad people. It catches perpetrators, it catches abusers. That is the whole point behind it. And it's sad that this is a policy that we've been unable to enact in this state. We are surrounded by states that have some type of parental notification, even parental approval, and we've never managed to get parental notification in the state. And as a result, we have become effectively a destination for abusers to take their victims, and I think that is a big mistake. Anyway, I won't go on any further, other than to say that if this language goes further, I would respectfully ask that the language be made more clear as far as the title of the bill, to reflect that this bill is actually about abortion and not privacy. And the question must absolutely be clear to the voters of the state of Connecticut what they are voting on. And to suggest that they're voting on reproductive freedom, when in fact the term reproductive freedom really means abortion, that needs to be updated so that it is clear to the people that would be voting on that subject. Thank you for the time, Mr. Chairman.